So Emami is an employment standards officer with the Ministry of Labor, Immigration, Training, and Skills Development, where he enforces employment laws, investigates workplace complaints, and supports fair and compliant workplace across Ontario. With a background in environmental assessments, regulatory compliance, and sustainability projects, he brings a strong analytical foundation to his work. Guided by integrity, fairness, and a commitment to continuous learning, Shay is dedicated to fostering safe, equitable, and legally compliant working environments for employers and employees alike. Then we have Carey Foster, who is an employment standards officer with Ontario's Ministry of Labor, Immigration, Training, and Skills Development, where he enforces employment laws and promotes fair, compliant workplaces across the Central East region. He is passionate about educating workers on their rights and supporting employers in meetings Employment Standards Act requirements. With a background in management, hospitality, consumer service, and immigration consulting, Carey brings strong legal, interpersonal, and leadership skills to his role. Outside of work, he is a dedicated husband, father of two, sports enthusiast, and emerging writer. So we will welcome both Ministry of Labor officers.
Good morning, everybody. As mentioned, I'm Carey Foster, and we're just going to do, an overview of the Ministry of Labor. So just give you a heads up on what the Ministry of Labor does, and then a second part will be we'll go into a little bit more on the Employment Standards Act. So essentially, the full title is Ministry of Labor, Immigration, Training, and Skills Development. So it's a long name. It's one of the longest names for any ministry. So if you see MLITSD, same ministry. If you see MOL, same ministry. So we'll just go by whichever one's easier for anyone. All right, so just a little legal disclaimer. So essentially, this is just saying that what we're providing here is not legal advice. We aim to just ensure that the information is current and up to date, but it is not legal advice in terms of the Employment Standards Act. So we're just here to just provide a little bit of guidance versus giving advice. So if you need advice on anything, you should seek legal counseling or contact the Ministry of Labor for more information. All right, so a little bit about the Ministry of Labor. So the ministry was established in 1919, and it's essentially to enforce labor legislation. The main mission is safe, fair, and harmonious workplaces, which essentially works the well-being of the people of Ontario. So that is kind of the focus of the ministry. The three main areas of responsibility of the Ministry of Labor is occupational health and safety, employment right and responsibility, and labor relations. So again, the bigger focus is always on safety and a harmonious and healthy workplace. And that's why there is a division under the Ministry of Labor specific to that. So that is the Fair, Safe, and Healthy Workplace Division. And this is the largest division under the Ministry of Labor, essentially because we feel like it's the most important, aspect of delivering the ministry's mission. So essentially, we call it Fishwood. Again, there's a lot of acronyms in the ministry, so forgive me if I just use an acronym. It's just ministry language, and I try to make sure that everybody understands what I'm talking about. So yes, they call it Fishwood because of the SHW, but anyways. So essentially, it's just to ensure fair workplace practices and safety within the workplace, and I know that is important under especially construction. So within Fishwood, there's also different branches. One of the branches is the Occupational Health and Safety branch, and another branch is the Employment Practices branch. So we are a part of the Employment Practices branch, but as this is, mostly women in construction, it's important to also understand the occupational health and safety aspects. So, I'm not with that branch, so, I'll try to give you as much information as possible from that branch, but, I don't have the in-depth knowledge of that aspect. So what is the Occupational Health and Safety branch? So they develop enforcement strategies for programs under the Occupational Health and Safety Act. So essentially their main legislation is the Occupational Health and Safety Act. So that's where most of their powers, enforcements, like that, that's where it lives. So anything that's related to health and safety in the workplace, harassment in the workplace, like sexual harassment and so forth, that falls under the Occupational Health and Safety Act, or OSHA for short. Like I said, acronyms are everywhere. So there's different aspects of the Occupational Health and Safety branch, and there's, construction, industrial relations, health and safety. So there's different smaller branches, so to speak, or units under the Occupational Health and Safety branch. So we have construction inspectors, and they just work with construction sites. We have industrial inspectors. They go around to like factories and so forth, and that's where their responsibility really lives. But this, it's mostly geared to construction, and what I have here is just to make sure that you understand what your rights are within the realm of construction. So, like I said, there are inspections and investigations within the Occupational Health and Safety branch. So, as you can see, what they try to do is proactive visits, and then there's also reactive visits. What we try not to have is reactive visits. So the proactive visits is inspectors come in and they inspect the workplace, make sure that everything is right, the workers understand their rights and responsibility. They are provided with, for example, documentations. Posters are posted so everybody understands what their safety responsibilities are within OSHA. So that's where we're looking to have this, so that we can reduce the reactive visits. So as you can see, what the reactive visits are: fatality, critical injury, workplace refusal, complaints. So that is what we don't want. So when you see, for example, an inspector, approach a site, again, it's just to make sure that the employers, the employees are doing what they're supposed to do so that they could go home safe. And a big part of it is to promote the internal responsibility system. And the internal responsibility system is just essentially just that everybody knows within that organization that they're also responsible for their own safety. So if you see something as an employee, you report it, and it should be taken care of before it gets to complaints. So your managers, your supervisors, your foremen, they should take it seriously. So, a lot of times, I think inspectors, they can be abrasive. I've had conversations with them, but a lot of the times when they become forceful, so to speak, is if they see something that's not supposed to be happening. So for example, they approach a site and somebody's on a roof and there's no proper harness. They'll probably get a bit agitated and may approach that way just because they know the danger of that. They investigate accidents just because of things like that. So when they see that, it kind of just boils their blood. because again, they know what that could lead to. So essentially, they're just trying to stop that from happening. So like I said, we do a lot of proactive visits. And again, the aim is to just try to remove all the reactive. It happens, and if something happens and you see on the news, the Ministry of Labor is investigating, that's the OHS branch, because they investigate all workplace accidents, fatalities, injuries, and stuff like that. So again, that's really the goal. So powers of inspectors. And the main one is that an inspector may enter any workplace without a warrant or a notice for an inspection. And again, a part of that reason is we don't want to say, okay, we're coming to inspect you on Wednesday. And then you clean up everything, and then we inspect you on Wednesday, and then you go back to your normal practices Thursday. And all the hazards and everything that we're there to prevent just goes back to normal. So that's why they don't need warrants. They don't need to tell you that they're coming. They just show up, again, because it's to ensure that everybody is safe. That's the key to it. And once they're at the workplace, they could question anybody, handle, use, or test any equipment, machinery, material, or anything, check all the documents, all the registries, take pictures and stuff like that. So they have authority to do all of that. No warrants or anything needed. Once they're there, they could do all of that. This is essentially, if you have a complaint, there's processes. The OHS inspectors, they do investigate complaints. So if you have any kind of workplace harassment or safety claims, then you can file a claim. There's an online application, so you could just go online, fill out the form, the PDF form. It could take anywhere between 5 and 20 minutes, depending on the amount of information that you have to put in. And all the important details is usually marked with an asterisk, so you just fill in the information, submit it. Once you submit that, then an inspector usually comes around to, question everybody that's involved, and then they'll do a report at the end of the day. The orders or the enforcement tools that inspectors typically have, it's, for example, compliance commitment. So compliance commitment typically deals with minor administrative stuff. So they'll ask you to comply. So for example, they go in and they don't see the relevant posters that's up, then they'll ask the employer to comply. They'll assist them, they'll provide them with the posters, tell them where to find it, and then just give them a date to say, hey, comply. This is minor, but just comply. Make sure the posters are up, make sure everybody has a copy of the poster, so they'll do that. And that's, compliance commitment. Orders, it's where, they'll probably issue, for example, a stop order on work. Now I know, everybody kind of, when there's a stop order, work may stop. For how long? We don't know. And I understand that it impacts everybody, because if there's no work, you don't get paid. And everybody goes to work to get paid. Nobody goes to work for fun, I'm pretty sure. So you go to work to get paid. If there's a stop order, it impacts everybody. So I understand that, a lot of times people don't want to see an inspector issue a stop order, because everybody got bills. You got your mortgage, you got rent, you got to buy food. So nobody wants to see a stop order. But if a stop order is typically issued, it's because it's something very serious. It could lead to injury. It could lead to fatalities. So that's why they would issue a stop order. It's not anything against an employee. It's not anything against an employer. It's just to make sure that everybody is safe to go home to their family. So, typically that's it. And then you have tickets or fines, and we can also do prosecutions. So if, the employer is not complying or they have too much violations, it can eventually lead to prosecution of the employer. And this is just some information after an inspection, how you could just, follow up to just comply with the OHA. There's the next page would have the contact information for the Occupational Health and Safety branch. So there's the general inquiry. Email is there as well. the website. So this is just if you want to file a claim, the information is on the website. Everything is actually on the ministry's website. You have access to the actual legislation on the website. There's usually a guide that also helps to break down the legislation for you. Because, I mean, I understand nobody wants to read a legislation unless you're a lawyer. I have no idea why it's written that way, but it's complicated to just read the straight legislation. So what the ministry does is that they provide a public-facing guide to that legislation that provides all the breakdowns in simple language. So that's there on the ministry's website. So I do recommend you go and check it out because it outlines all your responsibilities, your rights. So we just want to make sure that the employer is not trampling on your rights. And that's essentially a part of what, Shay will talk about. He's the guy who will talk about how the money impacts you, so to speak. Because if you work, you should be paid. So essentially that's where he will take it. And I believe he is up next. So, sorry.
I just want to just add one point. So in terms of the construction part of it, one thing to point out is that, because I used to work there, so the one thing to point out is when you are calling that 1-800 number, you mentioned you can do it online. You can't call the phone number.
Yes.
You can call the phone number as well, and there's the contact center. And they do have the after hours. So it doesn't matter, it's not like a 9 to 5, it is 24 hours a day, 7 days a week, and somebody will answer your phone call and vet the information in order to communicate that to the area inspector, right? But one thing I want to point out too is that you can be anonymous. You don't have to give your name, right? So depending on the situation or the severity or whatever the case may be, and you fear anything, you can just give the information and let the inspector come out and take those. So you don't have to give your name or anything like that. And no fear of reprisals, but I'm sure you're going to get that and all that. So just wanted to point that out as well.
Yeah, and there is also reprisal under the OSHA as well. That is a very protected activity. So essentially reprisal is that if you're trying to, engage in any right that you have, an employer cannot punish you for that.
And anything reported to the Ministry of Labor will be investigated.
Yep, and they can't punish you for that either.
You cannot, like, once you call, I've had it where somebody has called in and then said, oh, I don't want to, I don't want to bring that forward because of whatever the situation is or whatever. Once it's set in the database, that's it. The Ministry of Labor has to go and investigate that concern from beginning and closing. Right? So you can't, once you report, you can't retract it. It's a done deal. It has to be investigated.
All right, and yeah, just to point out, yeah, it's anytime, day or night. There's also a manager on duty also at night as well to triage any calls that come in. So yeah, you can do that at any point in time. All right.
Hey guys, I'm Shay. So I'll be doing I'll be going over the Employment Standards Act. So I'll refer to this as the ESA. As Carey said, there's a million acronyms. So for today, we'll discuss the ESA, the claims process, and resources you guys have under the ESA. So let's start with what's the ESA. So this sets out the minimum standards that all employers have to follow. So like an employer can't decide that the employee is going to waive out some rights. So they can't be like, I'm going to hire you for $10 under minimum wage, no vacation pay, all of that. Even if you sign a contract, it's non-binding under the ESA. The ESA provides your minimum standards, and these are your minimum entitlements that your employer has to provide. Okay, so they can choose to offer you a greater right. So, okay, let's say you start a job with your employer. They can pay you the minimum wage, but they choose to pay you $25 an hour. That's a greater right by your employer. They can choose to give you 10 weeks of paid vacation. That's a greater right. So it's up to them, but they just can't go beneath the minimum standards. Okay, so let's start with who is an employee. So if you perform work for wages, you supply services, you receive training. So this is another thing we see fairly often where an employer is like, the person was just in training, so they trained for 2 weeks. I'm not paying them for 2 weeks because they were in training. Like I said, you're an employee if you receive training. Yeah, so even if you work from home as well, you're also an employee. As long as you're doing work for your employer, you are an employee under the ESA and you're covered. Yeah, so this is another thing we see fairly often at the ministry. An employer will rely on the person being an independent contractor and say, oh, like they're excluded from the ESA. So it's like they'll pretty much offer you an agreement at the start of your employment saying you're a contractor, so we don't have to provide you with the minimum wage or wage statements or any of those things. But the ESA takes account of that, and we have tests we run to determine if you're actually an employee or or a contractor. So for a contractor, you usually have control over your business. Like you choose your hours, you choose to work if you don't want to, but which isn't the same as an employee. As an employee, you have to report to someone. There's usually a boss that's providing your directions throughout the day or something, or gives you work to do, or connects you to work. The tools you use are usually provided by the company, so it's not like you call a plumber maybe to come fix your sink. He comes in with his own tools and everything, and all you do is pay him at the end. It's different than when you go into work and the employer has provided your computers maybe, or the employer has provided the job site. Most things will be provided by the employer. Chance of profit or loss. So if you're a contractor, the profit's all yours, the loss is all yours. If you don't find work, you have the losses are all yours. But if you're an employee, if your employer doesn't have work, you show up to work for an 8-hour shift, they still pay you for 8 hours, even if they're making losses. If they make more profit, it still goes to the employer. So that's another test. Then degree of responsibility, investment, or management. Like I said, again, the management, someone is probably above who you report to. You don't invest that much into your employer's business. You show up to work, you do your work, but it's not your personal funds going into this. You don't have to provide clients or any of those things. So these are usually the major things we use to determine if someone is an employee or a contractor. It's a lot longer. There's a bunch of questions, but this is a general overview. Okay, so the basics for an employer. First things first, they have to establish a recurring pay period and a payday. So they can't decide, oh, I'm just going to pay you anytime we get money for the company. You should have an established, it could be weekly, it could be monthly, it could be bi-weekly, but the employer should establish a recurring pay period and a payday. Then for the wages, they can be paid by cash, by check, e-transfer, direct deposit. Any way where the employee can receive their funds it's acceptable under the ESA. The employer also has to provide you a wage statement. This, it could be written, electronic, it could be with a pen and a paper, but it should explain all the wages earned for that pay period, and it should show any deductions that the employer has taken off your paycheck. Okay. So the employer also has to keep the records for at least 3 years. We see this all the time. There's tons of employers that don't have records, don't keep records. So we try our best to inform and educate, but these are the minimum standards. So this is just a slide showing the minimum wage rate as of this year. So there's a student minimum wage. There's a different wage for wilderness guides and hunting and fishing, or for people that work at home. That's not remote work. But this is just showing you the general. This is just showing the minimum wage for right now and for last year as well. So if you're employed this year, you should be getting paid at least $17.60 an hour, from October 1st this year. Anything prior, $17.20. Yeah, so next we jump into my favorite part, overtime pay. So For most employees, if you work past the 44-hour threshold a work week, sorry, which is essentially when your pay period starts in a work week. So if they run the schedules at your job from Sunday to Saturday, if you work past 44 hours from Sunday to Saturday, you're entitled to your overtime pay. It's usually at 1.5 times your regular rate. So I'm sure everyone's familiar with overtime rates here, maybe? I hope so. Yeah, but there is an exception. So if you work in road building, which I added up there just because you guys are in the construction field, so you might be working with roads, your overtime work week threshold starts at the 55-hour mark. I don't know why this is different, but the ESA, this is the regulation under the ESA. So for road building, I have this, this is if you work construction of roads, repair, remodeling, maintenance, highways, or parking lots, the ESA has pretty much taken all of these people, and your overtime rate starts at the 55-hour mark. An employer can choose to average your overtime hours typically over 4 weeks. So what that is for 4 weeks, they can take the max amount of hours and divide them by, the total amount of hours divided by 4. If those hours don't cross the 44-hour threshold, like the average doesn't cross the 44-hour threshold, then there's no overtime pay. But for this, you have to agree in writing with your employer. So if they offer you the averaging agreement, if you don't want this, if you don't agree in writing, then the employer doesn't have the right to force this on you. So for most things with the ESA, you see, like, going forward, you need a written agreement. You need to agree with the employer for the employer to impose these things on you. So next we have vacation time and vacation pay. So what this says if you've been employed for less than 5 years, you're entitled to 4% of your gross earnings in vacation pay. So where you see VEY there, that's the vacation entitlement year. I'm sorry, as Carey said, there's a million acronyms for everything. So the vacation entitlement year is the year in which you earn your vacation. So like I said, if you work for less than 5 years, you get 4% of your gross wages as vacation pay. This can come in on every paycheck, like it can be 4% on every paycheck. You might have seen it on paychecks at some point. Or you can get this as 2 weeks of your vacation pay. So you know how, like, at times you request your vacation, you're going away for a week, and you still get paid for a week. This is where that comes from. If you work over 5 years, it's 6%, or that usually translates to about 3 weeks. Okay. So with this, the employer also picks, technically they have the right to pick when you can take your vacation. So that's why they're allowed to deny your vacation requests at times. But the vacation must be taken no later than 10 months from when it's earned. So if you start earning your vacation for this year, it has to be taken at least 10 months from after it's earned, and that's just to comply with the ESA, okay?
Yeah, so if your vacation year is from January 1st to December, so you would earn that time during this year, then you have to take it by October of next year, because that's a 10-month. If the company's vacation is January to December, if that's their entitlement year.
Thank you, Carey. Yeah. So, unfortunately, a lot of this, it gets really tricky. I tried my best to simplify this as much as possible. As Carey said, they don't make. There's a bunch of exceptions, exemptions under the ESA. If you have a union, that's a whole other thing. If you have a collective agreement, a whole other thing. But this is just the minimum standards, just so you know what you should be getting at your workplace. So I have this slide on leaves. This shows the leaves provided by the ESA. So you get unpaid time off work for the following leaves, and these are the minimum entitlements that your employer is supposed to provide. So this pregnancy leave, parental leave, sick leave is one that we get a lot. So you are only entitled to 3 unpaid days of sick leave. The employer has to let you take 3 unpaid days of sick leave a year. If there's paid sick leave, that becomes a greater right. So it's the employer choosing to let you take more sick days in a year, but the ESA only provides you 3 unpaid sick days. Yeah, so there's a ton of them actually. I can't go over all of them, but like just the first slide there has the ones we see the most common. Next will be for termination. So this says that as a regular employee employed for more than 3 months, the employer is supposed, like if they decide to terminate your employment, like if you haven't done anything wrong, they're just like maybe there's no profit and the employer wants to cut down employees, they have to give you notice of termination. So if you've been employed for for 3 months up to a year, they give you a week of notice. This goes up to 8 weeks if you've been employed up to 8 years, and then it caps at 8 weeks. But they have to give you this notice of termination. So it's pretty much just them, like they tell you, oh, in 2 to 3 weeks your employment will end. They can choose to give you the notice, or they can just pay you in advance and end your employment immediately. So if you've been employed over 3 months, they give you a week of pay. They end your employment immediately. Most employers won't do this. They just tell you, oh, employment's over, blah blah blah. Like, yeah, we try our best. We inspect, we inform, but there's still some people that don't follow all rules. So there is a note down there. So for most of the construction employees, except those in road building, you're exempt from notice of termination or termination pay. This is another rule under the ESA, and I felt like it related to you guys, so I added that in there. Yeah, so I have a sample on the side here. So 3 years to less than 4 years, you get 3 weeks of notice. After 4 years, 1 week per completed year, up to 8 weeks. Then equal pay for equal work. Yeah, so this says that your employer cannot pay 2 employees at different rates if the basis for the difference is if it's based on sex. You know what I mean? Like paying a man and a woman in the same role different rates just because the person's a guy and the person's a woman. So there's like a little explanation for this. So it's like they have to be doing the exact same work in the same establishment, and the work should require the same amount of skill, effort, and responsibility, and it should be under similar working conditions. All of these must be met for equal pay for equal work to apply. Right, so it can be like there's also the exceptions for this. So it can be like, oh, this person's a senior employee and I'm a junior employee, and then there's this. So you still have to understand that like seniority, like there's merit factors and all of that go into play. But it just says that if you and another employee at the exact same level, same job duties, you shouldn't be getting paid different rates just based off sex. Reprisals, yeah, so this is another major one we see all the time. You shouldn't be punished, threatened, penalized for attempting to exercise your rights under the ESA, or for telling your employer to act with the ESA. If your employer isn't paying you any wages, you go ask for your wages, and the employer is like, okay, I'm gonna cut your hours, I'm ending your employment, or anything along those lines, just because you're asking them to follow the ESA, that would be a reprisal. If you go ask for your vacation pay and the employer is like, I'm not paying you vacation pay, and then all of a sudden, a day later, he sends you a termination, that could be a reprisal. Like, it just says that the employer shouldn't punish you for exercising your rights. If you file a claim and we contact the employer and they terminate your employment, could be a reprisal. So this just states that like this pretty much protects you from your employer penalizing you just because you're trying to exercise your rights. So with this, so what this is we investigate the reprisal, and if the employer has actually, if we find that they actually did penalize or threaten you based off of this, then we can we usually order a compensation order. So this is where they can pay you for the loss of job, or like time to find a new job, pain and suffering, or if you want to, or we usually try to get you reinstated back at your job, at your position. But most times we find that isn't the best option because the employment relationship is already sour. Both parties hate each other already. It's already unfavorable. So yeah, so we see a ton of these. I should state that it's only a reprisal if it's a protected right under the ESA. So there's a long list of rights. I don't have a slide on protected rights, but if you go on the ministry's site, it gives you a list of all the protected rights. Yeah, so to file a claim, similar to what we heard before from Carey, you go on the website, you fill out all the information in there. It typically will ask you name, address, employer name, employer address, your work location, and asks you to put a little, just explain your claim in there. I will say, if you plan to file a claim, or you keep all your evidence, as much evidence as possible. We make our decisions based off the best available evidence. So text messages, pay statements, always keep hours of work records. All of that's really important. The claims process, yeah. So when you file your claim, it usually gets, it reaches the ministry. At the first stage, it's usually sent to an early resolution officer. So they try to resolve it at the first step. They'll reach out to yourself, the employer, try to see if they can work on like a settlement between you guys. If that doesn't work, then it gets escalated to us, and we do a full investigation. We take all the evidence from both parties, and then we try to make a decision. So if we find that the employer is at fault, anything was done wrong, yeah. So we can either reach out to them and ask them to comply with the ESA. So fix what you're doing right now, provide wage statements, hours of work, all of that. Like, just go along with the ESA. Or if we find your owed wages, we can order the employer to pay you your wages. Or we can order them to reinstate, like I said, for reprisals, or pay a compensation order. If we ever reach out to them to pay anything, it comes with an admin cost as well. So most employers will try to avoid the admin cost, and like at some point in the investigation, they'll work on a settlement or just offer to pay the employee. Okay. Yeah. So on the last slide, this is just the resources we have. If you want to take photos, but this is all available on the ESA website. Yeah, that's everything.
So now we'll have the panel on building inclusion from the inside out.